Hello, I'm Andy Oakley on New Zealand Issues. Today's issue is the third and final instalment of Why the Treaty of Waitangi Act 1975 is fraudulent misrepresentation and must be repealed. So previously we've learnt that sentence 1 of the preamble in the Act is a lie because it states the treaty was between Queen Victoria and the Maori people of New Zealand. However, there was no collective of Maori people known in New Zealand in 1840. The treaty is addressed to the people of New Zealand in the Preamble, all of the people of New Zealand in Article 2, and the ordinary people of New Zealand, along with the chiefs and rangatira in Article 3. Maori are not even mentioned in the treaty. We learnt that sentence 2 of the Preamble is also a lie, because it states there is a difference between the English language treaty and the treaty in the Maori language. However, there simply was no, and is not now, an English text treaty. That is a barefaced lie. Today, we're going to learn that the tribunal set up to uphold the treaty principles have lied about what the principles are and have made no attempt to protect them. The third and final sentence of the preamble in the legislation states, "And whereas it is desirable that a tribunal be established to make recommendations on claims relating to the practical application of the principles of the treaty, and for that purpose to determine its meaning and effect and whether certain matters are inconsistent with those principles." So we see that the sole reason for setting up the Waitangi Tribunal is to protect the principles. Now the word principle means a fundamental truth. And to establish the fundamental truths of the treaty, one would need to read the English text draft of which Te Tiriti was translated from. And that's because no one can agree on what each of the chiefs who signed Te Tiriti understood the words in Te Reo Māori to mean. For instance, if you were to look up the word taonga in a dictionary pre-1840, it meant property. However, Professor Kafaru told the Waitangi Tribunal in his 1989 back translation that it meant treasures. He used the same word trickery to change the meaning of the words possessions of their land in the draft, written as Tino Rangatiratanga Rato Wenua in Te Tiriti, to the chiefly authority of their land. So apparently the chiefs ceded sovereignty in Article 1, but according to Kafaru and now the Waitangi Tribunal, they retained it in Article 2. Now how could that be possible? In any case, we have the English text draft written by James Busby. You can read it in both of my books, or simply Google Littlewood Treaty and click on Read the Treaty, and there in front of you are the fundamental truths of the Treaty of Waitangi, addressed to the people of New Zealand in the Preamble, and to preserve their land and to maintain peace and order. Article 1 clearly states that the chiefs are to cede sovereignty of the entire country to the Queen of England forever. In Article 2, the Queen confirms and guarantees to all the people of New Zealand that she will introduce property rights. This is because none existed in New Zealand previously. In Article 3, she states that in return for ceding sovereignty, she will protect us all and that we will have equal rights. These are very clear and relatively simple principles or fundamental truths, all written in the English language, so there could be no doubt about the intention of the treaty. Since the Waitangi Tribunal's sole existence, as it states in the preamble of the legislation, is to make recommendations on the practical application of these principles, let's quickly measure how they're going. Do they agree with the fundamental truth, as it states in a draft, that the treaty was addressed to the people of New Zealand? No, they don't. They have changed who the treaty was addressed to Maori people, defined as a separate race in the same legislation. Even though scientists have debunked the concept of race and there not being a single person known as a Maori person in 1840. How about the cessation of sovereignty of the entire country as stated in Article 1? Are they protecting that? I mean, that's a pretty important thing for our country, isn't it? No, they're not. In 2014, the tribunal stated in a report that the chiefs thought a government was set up to govern Europeans, and they had no idea that they'd signed away sovereignty. That's, of course, despite the fact that we've had a parliament that's held our sovereignty for 174 years. Or what about the property rights principle mentioned in Article 2? How's that going? Well, despite chiefs willingly selling 96% of the landmass of New Zealand, for which deeds of title can be searched on the internet, the government, on the recommendations from the Waitangi Tribunal, are in the process of giving it all back, along with an apology and hundreds of millions of dollars. Property rights mean nothing to this tribunal. How about the protection and equal rights principle promised to all New Zealanders in Article 3? Well, have any of you who are non-Maori tried to make a claim to the Waitangi Tribunal for breaches of the treaty that was addressed to us all? Well, I have. And although I have not met any of them, I was told by the Waitangi Tribunal that I am not a Maori, and so the claim would not proceed until I proved I was. I've since asked them for a definition of what a Maori person is, to which they will not reply despite me sending many reminders. Now that's just one of a plethora of extra rights and privileges available for Maori that non-Maori are excluded from. So the Waitangi Tribunal have struck out on every one of the treaty principles that they have been entrusted with protecting. They are incompetent, racist, and are responsible for a steadily worsening relationship between Maori and non-Maori in New Zealand. We can see through the series of 3 videos that I've made regarding the fraudulent Treaty of Waitangi Act 1975 that we must repeal this act and close down the agency of lies known as the Waitangi Tribunal, who operate within our Ministry of Justice, no less. For more in-depth and referenced examples of how corrupt this claims process has been, you could read my book, Once We Were One, The Fraud of Modern Separatism. I've been Andy Oakley. Noho oro mai.